Let me take you back first. The American constitutional order was never built to be unbreakable. It was designed to bend under pressure, to absorb shocks through separation, delay, and mutual suspicion among branches. The framers understood human nature too well to trust any single office with final power. Consider October 1973. On a Saturday night, President Nixon directed the firing of Special Prosecutor Archibald Cox, who was closing in on evidence of White House obstruction during Watergate. Attorney General Elliot Richardson refused the order and resigned immediately. His deputy, William Ruckelshaus, refused next and was dismissed. Only the third in line, Solicitor General Robert Bork, carried out the firing. The event became known as the Saturday Night Massacre. Here's the thing. The Republic did not collapse that night. It survived because individuals chose institutional duty over personal loyalty. Richardson and Ruckelshaus did not negotiate. They did not delay. They acted, knowing the cost. The courts continued issuing subpoenas. Congress accelerated its investigations. The machinery, though damaged, kept turning. This pattern repeats across American history. In 1987, during Iran-Contra, Congress uncovered systematic evasion of law by executive officials. No single judge referred criminal conduct directly to the legislative branch for impeachment. The committees did the work themselves. In 1998, during the Clinton impeachment, the House acted on evidence of perjury and obstruction developed through independent counsel. Again, the judicial branch did not formally demand legislative intervention. Each crisis tested the same question. When one branch defies the others, who enforces the boundary? The answer has always been the same. No branch possesses absolute power to compel the others. Enforcement depends on choices made by people inside the institutions, judges who issue orders, prosecutors who pursue evidence, legislators who vote, officials who resign rather than obey unlawful directives. This reliance on human judgment is both the system's greatest strength and its deepest vulnerability. When individuals inside the machinery choose to defend it, the order holds. When they do not, the damage accumulates quietly until the next breach becomes visible. What happened on January 10, 2026, in a federal courtroom in Washington, D.C., belongs to this lineage of tests, but it also marks a departure. For the first time in 249 years, a lifetime appointed federal judge concluded that her own tools were insufficient to protect the administration of justice. She did not wait for Congress to discover the problem. She formally transmitted it to them. Stay with me here. The gravity lies not in the act alone, but in what it signals about the state of the machinery itself. Direct your attention to the courtroom in the District of Columbia. Federal Judge Tanya Chutkan has presided over one of the criminal cases against former President Donald Trump since its inception. Her role demands impartial enforcement of procedure, regardless of the defendant's status. For months, she confronted a pattern no judge in this position had faced at such intensity. The defendant violated court orders repeatedly. These were not minor lapses. They involved public statements that targeted witnesses, prosecutors, and potential jurors. Social media posts defied gag orders designed to protect the trial's integrity. Contacts with co-defendants occurred despite explicit prohibitions. Federal judges possess a toolkit for such defiance. They issue warnings first, then fines. Contempt citations follow if needed. In rare instances, they revoke bail or impose detention. But these tools assume a defendant who responds to consequences. What unfolds when fines hold no weight for someone of immense wealth? When warnings are dismissed as mere advice? When political considerations make incarceration untenable? Judge Chutkan issued warnings in 7 separate hearings. She levied fines that accumulated without altering behavior. Contempt findings were entered into the record 14 times over 3 months. Each violation was documented meticulously. Timestamps marked the infractions, screenshots preserved the content, transcripts captured the courtroom exchanges, yet the conduct persisted. This escalation trapped the judge in a dilemma central to judicial authority. Orders must carry force or the court loses its function. Tolerance of repeated defiance signals to all litigants that compliance is optional. The problem extended beyond one case. It threatened the federal judiciary's credibility nationwide. By January 10, 2026, at 3:17 p.m. Eastern Time, Judge Chutkan determined her options were depleted. She could no longer contain the threat within her courtroom. The administration of justice required intervention from another branch. This matters profoundly. It reveals how institutional limits, when reached, force a transfer of responsibility. The judge did not act lightly. She compiled evidence that demonstrated not just actions but deliberate intent to undermine the process. Let me explain why this shift alters the balance. The judiciary, by design, avoids political arenas. Crossing into congressional territory signals a crisis where legal remedies alone fail. Now consider the document itself. At precisely 3:17 p.m. on January 10, 2026, Judge Chutkan filed a 47-page criminal referral in the federal court docket. This was no ordinary filing. It transmitted the full evidentiary record directly to Congress, with a demand for immediate impeachment proceedings. The referral outlined 14 violations of court orders. Each was supported by timestamps, archived posts, and transcripts. Phone records showed unauthorized coordination with co-defendants. Internal communications from the defendant's legal team admitted the breaches. Sworn statements from former federal judges described the conduct as without precedent. Most critically, the document included audio recordings of discussions among the defendant and advisors. These captured explicit plans to disregard judicial directives. This evidence shifted the narrative from accidental lapses to calculated obstruction. Intent, once inferred, became provable. The language employed carried precise legal weight. The judge wrote of a clear and present danger to the administration of justice. This phrase, drawn from established jurisprudence, signals an imminent threat that justifies extraordinary measures. It compelled congressional attention. She attached the entire record, not a summary. Congress received screenshots, hearing transcripts, and expert analyses. The referral urged the House to act without delay, citing exhaustion of judicial remedies. This step breached a long-standing barrier. Judges traditionally resolve disputes within their domain. Referring criminal conduct to another branch admits that the judiciary cannot safeguard itself alone. It invokes the Constitution's interbranch design, where one power checks another. Stay with me here. The referral did not merely report facts. It framed them as a constitutional emergency, demanding legislative tools like impeachment that courts lack. The stakes now involved not just one trial, but the separation of powers itself. Turn now to the House of Representatives. Within hours of the referral's filing, legislative machinery activated with unusual speed. Articles of impeachment, drafted quietly in committee since November 2025, listed 8 charges, including obstruction of justice, witness tampering, and threats to the constitutional order. Initially, these held 87 co-sponsors, all from one party, far short of a majority. By evening, that figure reached 231, securing passage. The surge came not from expected quarters but from moderates in competitive districts. Representatives who had twice voted against impeachment now defected, citing oaths to the Constitution and the judge's evidence. One held a press conference, stating the referral demanded serious consideration. Another echoed the sentiment, framing it as duty over loyalty. These were not isolated acts. They reflected calculations about electoral viability amid documented violations. Leadership invoked a procedural rule for expedited action, mandating a vote within 72 hours. Filed that morning, it set the deadline for January 13, 2026. With commitments locked, the outcome shifted from possibility to certainty. The focus turned to the vote's margin and further defections. This rapid alignment exposed underlying fractures. Loyalists labeled defectors as disloyal, while pragmatists weighed evidence against political risk. The referral provided cover, transforming private doubts into public stands. Here's the thing. Defections cascade in such moments. Each one eases the next, eroding coalitions built over years. The process, once started, accelerates through human choices under institutional pressure. Let me explain why this mobilization redefines the crisis. It moves accountability from judicial isolation to collective legislative judgment, where numbers determine enforcement. The stakes now encompass party survival and electoral futures. Examine the immediate fallout. The defendant's reaction unfolded publicly on his social media platform. Posts in rapid succession decried rigged systems and partisan judges. One statement stood out. It urged supporters to converge on Washington if proceedings advanced, invoking constitutional rights in a manner law enforcement interpreted as a call to arms. This rhetoric did not dissipate. It amplified the referral's evidence, providing fresh material for ongoing probes. Federal agencies treated it as a credible risk. National Guard deployments encircled key sites. Barricades fortified buildings. Aerial surveillance intensified. Protesters from both sides assembled near government landmarks. Authorities positioned to prevent escalation, drawing lessons from prior breaches of security. The atmosphere in the Capitol grew charged, with closures and heightened alerts affecting daily operations. Parallel to this, the referral reached the Department of Justice. Prosecutors reviewed the same record for potential new charges like witness tampering and obstruction. Grand juries in multiple districts remained active, poised to indict independently of congressional timelines. Discussions of the 25th Amendment surfaced discreetly among officials. This mechanism, requiring vice presidential and cabinet consensus on incapacity, offered a swifter removal path. Its mere consideration underscored perceived instability. Internationally, allies expressed concern through diplomatic channels. Adversaries monitored for exploitable weaknesses. Domestically, the Republican coalition splintered further. Loyalists rallied defenses, while others distanced themselves amid threats to their safety. This convergence of pressures, rhetorical, legal, and physical, transformed a judicial act into a multifaceted confrontation. The risks now extended to public order and global perceptions. Reflect on the broader horizon. The events of January 10, 2026 do not conclude with a vote or a trial. They embed themselves into the constitutional fabric, altering how branches interact for generations. A judge's referral sets a precedent that future courts may invoke when facing unchecked defiance. Congressional defections signal a realignment within parties. Coalitions once anchored by loyalty now prioritize evidence and oaths. The midterms in 2026 loom as a referendum on this shift, with chaos potentially reshaping electoral maps. Parallel investigations ensure accountability persists beyond politics. New indictments could intersect with legislative actions, testing the system's capacity to handle concurrent pressures. The 25th Amendment's shadow reminds officials of removal options in extreme instability. Globally, the episode erodes perceptions of American reliability. Allies recalibrate partnerships. Adversaries exploit divisions. Domestically, markets fluctuate under uncertainty, delaying investments and straining resources. Trust in institutions erodes further. Citizens witness rhetoric turning to threats, guards deploying against their own. Rebuilding requires not just resolutions, but demonstrations that processes constrain power effectively. This crisis affirms the framers' design. Human choices within the machinery determine its endurance. Yet it exposes vulnerabilities when defiance scales beyond traditional remedies. The republic emerges changed, with boundaries redrawn through accumulated facts and deliberate actions. The significance lies in this irreversible mark on history.